You will be removed to the next courtroom. Stop interrupting me. Illinois versus Allen, sir. I was abundantly patient with you yesterday. Your belief that that's the law doesn't make it so.
My name is Jimmy T, and I sign damn keys. I command respect, decorum, civility. You have to eat fuggy cereal and government cheese, but that don't make you innocent to home society. You have all these stupid thoughts regarding sovereignty. I dismantle all your arguments like it's a breeze. I make the rules and get your rule on what the jury sees. You'll swallow shitty tea and bring you to your knees. I drop the hammer, make you simmer. You may even call me slick. Toss you in the slammer, just like Gamer, prison's new silly trick. Have the law on my side with the rule book that's thick. I murk you legally and make all your charges stick. You're heavy spinning on this flow with rhymes this sick. Your feel will mean nothing when your ass gets kicked. So go find a real lawyer who can suck my dick. Join me, y'all. Fuck you, Joe Brooks. I don't give a fuck. Parade driving bitch. Go fix your nasty fucking teeth. I'll do it. I don't give a fuck. Go 12 years of dental school. Your ass will still be in jail. Open up a whole class practice. I don't care. I'll be doing oral surgery with my massive judge cock. Hey, go get inmate Darrell again while school needs cleaning. Oh, no, Mr. Brooks. Wrong end. Turn around. There you go. That's right. All of it. Oh, watch the teeth. There you go. Who's a pretty girl? Who's Jenny's pretty girl? Jenny D's little dick cleaning machine, huh? Just starving for this laudable dick. Famished. Look at him, putting in that work. Hungry little fella. Hungry hippos over here. Alright, I'm out. Judge C, I'm out. Fuck the police coming straight from the underground.
You may make an offer of proof, sir, as it relates to why or what questions and what information you believe this officer would provide about news reports that he has seen.
So the offer of proof would just be to that one question?
What would the question be?
The question was, would have been, if I was allowed to finish it, had he seen any news reports directly connected to the incident?
But what's the relevance?
The same thing that many other witnesses have been asked, and it was never sustained then. It was never even objected to.
Just because you got away with it once does not just give you free reign to ask anybody that same question at any time. It would be the same if you were to say, just hypothetically, get away with murder, which you did not, but let's pretend for a second that you did. That does not give you like a get out of jail free card on any murders you may commit moving forward for the rest of your life. The question probably should have been objected to the first time. You pointing it out only seeks to disparage your previous lines of questioning.
So it was the same. It was
Let's
essentially
focus
one of
on
the same
the
questions.
specific objection that was posed and my
And what was the grounds for
willingness
it?
to give you an opportunity to provide the court with an offer of proof. This was what relevance would this particular witness seeing news reports have to his testimony?
The same thing that any other witness that was asked the same question.
Which would be what? You have to be specific, sir.
I
I'm not
was
gonna
specific.
assume I understand what you are saying.
Have they saw any reports related to the incident? That's the same question that's been asked by numerous
Well, there would
witnesses.
be a follow-up to that. So how is it relevant to this witness's testimony?
It's relevant to anyone who gets on the stand's testimony.
What's the legal basis you believe it's relevant to his testimony, sir?
It obviously forms an opinion.
It is obvious.
Again, I'm not, you need to explain to me, sir, the legal basis why you believe I should allow that witness to be asked that question and then any follow-up based on his response.
What would have been the follow-up?
I'm asking you, sir, you're the one who's the proponent of this particular testimony and this questioning and the evidence. So explain to me your legal basis for why you believe it's relevant to ask, or any other reason, any legal basis you believe it's that I should allow that question to be asked.
I don't understand how you want me to answer that.
I know you don't, Darrell. That's because you do not know yourself how somebody watching a news report might possibly relate to your case. So just do us all a favor and move on. Let it go. You won't, but you should.
I've stated the reason why I asked the question.
No, you stated it's obvious, but it's not obvious to me, so I'm asking you to explain it.
I also stated that it mind-boggling. I just clearly stated. Clearly.
Clearly. He stated it clearly. It's clear. It's obvious. I think that it's obviously clear. It is clearly, obviously clear. It would be fair to say that it was very clearly stated that it is obviously clear. Obviously.
That it goes towards biasness.
This has been another iconic Darrell Brooks moment. This iconic Darrell Brooks moment is brought to you by Clearly Window Cleaner. Clearly your best choice when you need things pretty clear. Obviously.
That it goes towards biasness.
I'm
that
sorry,
would
it goes
be
to
relevant.
What? Wait, it goes to what?
Biased.
Bias?
Biased.
No, bias. B-I-A-S.
Got him!
There's no T at the end. Bias. I want to make sure I understand your
now it's
reasoning
about
correctly,
how
sir.
to
So
correct something.
it's
How to
you're
pronounce
saying it
something.
goes to bias. How does it go to bias of this witness, sir?
How would it not go to if you see something in the news?
It's not a proper legal argument, sir.
She's laughing at him. Oh, that's glorious. Judge. Oh, what a savage.
Okay, well, I don't know how you want me to answer
How
that.
would what he saw subsequent to his investigation impact either what he did beforehand or his testimony here? You have to make an offer of proof as to that. Without that, I'm not going to allow it.
You didn't allow it anyway, so what do it matter at this point?
I'm giving you the opportunity. It's called an offer of proof.
Okay,
I said I would
know
recall the
I'm
witness
well aware,
if I
I'm well aware
determine.
what an offer of proof is.
You know, you say that, but you're not actually offering any proof in response to what she's asking. An actual argument might sound something like this. Your Honor, the witness's knowledge of news coverage is relevant because it implies that the testimony he is providing has been tainted by information provided within said reports. Second-hand accounts of an event in relation to the charging instruments is essentially hearsay. Therefore, this witness's testimony may as well be inadmissible. I move to strike said testimony from the record and move on to the next witness. That's an argument. It might not be a very good one, but it's certainly better than simply implying something is obvious without actually providing an explanation as to what that something is.
I'm
Okay,
well aware.
so make your offer of proof.
I don't need to. It's clear.
Oh, that sweet little snicker to herself and how stupid this man is. It's just, oh, mwah. It's the chef's kiss, the piece de resistance. It brings it to a new level for me. It hits different. It is the sweet, sweet nectar to us Darrell Brooks junkies. It may as well be pure, uncut raw cocaine. Just to us DV junkies. Like, this is our fix. Just shoot it right up into the veins. Like woof. What a rush. Beautiful. Oh. Almost makes all the pain and suffering of watching this heinous piece of shit every day just a little more tolerable.
It's very clear. I don't see anything funny either.
It's not funny, sir. It's a circular argument. You're telling me that it's clear.
I wasn't referring that to you. The person that it was referred to know who they are.
Oh, well, call them up by their name then, B. Come on, I thought you were about that life. What happened? Big bad Darrell, I thought we could get on that if that's what this is. Well, fucking what now? Be bold enough to say it to their face. Fucking punk ass bitch. He's on this passive aggressive S like a full blown Karen. You gonna fucking ask for their manager too? What happened to that dog in you, Mr. fucking shackled to the table? It's almost as if you're all talk and actually only get a bond at when you're beating on or intimidating women. But when directly challenged, you cower down like the simp, soy boy, little boy that you are. Pathetic.
Well, let's stay on task, please. So,
I'm trying to.
You're
but
claiming
it's hard.
it goes to bias, but in what way?
May I say this for the record, Your Honor? It's hard to stay on task when it seems like the prosecution can ask essentially anything they want to ask.
Mr. Brooks,
but then when I
had an objection before. Well, here's the thing: you want to go off target, and you want to bring up things from the past. I can't explain to you why sometimes the state has an objection and other times they don't. But when an objection has been made, it is my obligation to rule on it. And so there was an objection.
I'm aware of that, Your Honor. But I'm also aware of the fact, and it's clear that I object quite often, and every single time I object it's just thrown to the side every single time.
Well, I would disagree with that characterization, sir.
And
I make my rulings in this
why
case
would you disagree
based.
With that?
I'm like an
Can you point
umpire.
Out one time?
I'm like an umpire in a baseball game, sir. I call and see the legal objections as I see them. That is my role, and that is what I do. And
are you kidding me?
Oh my good God, he is fucking stupid. He acts as if it's just a game of percentages, and rather than the objection being overruled or sustained, is not actually based on the merits of their grounds, but rather than each party just gets an equal number of sustained per objection. But in reality, if she were to simply sustain the same amount of objections regardless of their validity, that would be unfair, because now both sides are not playing by the same rules. Just like in a baseball game, per her own reference. Each team comes into that game with the understanding that there are a set of rules, and their levels of success within that game are based on their own respective ability to play within those rules. If each team just got an equal number of runs regardless of how many strikes or hits they got, that would be unfair. But, of course, it's only unfair if it isn't benefiting him. If the shoe were on the other foot, and it was the state crying about their objections being overruled, he'd be on the same bullshit about things not being fair. Such a fucking moron!
That's exactly what I do. I'm an umpire, sir. I am a referee in this trial.
If you're the umpire,
and let me finish.
Okay.
Let me finish,
okay.
Mr. Brooks.
I apologize. I'm letting you finish.
Sometimes parties make objections, sometimes they don't. There can be a variety of reasons. You make a lot of objections in this case. From my perspective, okay, you make a number of objections, I rule on them, and you disagree with them. But that doesn't mean I'm casting things aside. I'm making a call based on the rules of evidence. So, for example, if there's a relevance objection, I'm going to analyze that, okay, based on the objection that's been made. Sometimes I might think there's another basis for something to either come in or not come in. But my rule book, okay, is the rules of evidence, which are the statutes, which once again, I'll point out, I gave you, sir, near the beginning of this trial, so that you would have a better understanding of what those rules are. If you choose not to read them, that's fine. But you cannot then claim that there is somehow foul play because you haven't read them and you don't understand what they are. Your ignorance of the law is not a defense for any of this. Okay? And you getting frustrated with me because you don't understand that, I mean, it's just what it is. But I'm calling these legal shots as I see them. And I've asked you repeatedly for an offer of proof. You want to ask this witness who had limited involvement regarding a part of an investigation related to that vehicle. I don't see the relevance, even to bias, for which I will allow him to answer that. You haven't given me a legal or factual reason to overrule the objection and to bring the witness back on the stand and to question him about his viewing of any news reports. So with that, we are going to take a very short break. The jury's been out for a little bit, but I recognize it's 3:25. It will be a good opportunity for a comfort break, and when we come back on, the state should be prepared to call the next witness.
Can I release at least rebuttal to what you just said since you asked me not to?
I don't need a rebuttal, sir. You may not agree with me, but I've made
It's not about agreeing.
record.
You just told me not to interrupt you, and I didn't. So I at least deserve the chance to put on the record a rebuttal.
Her response was so poignantly articulated. I mean, it was foolproof. Fucking present company excluded, though, I guess. Any logical human being in his position capable of reading and interpreting a room would know that there is nothing you could possibly offer to rebut what has just been said. They are the facts that are before him, in as plain and simple terms as there are. And you know what? Furthermore, seeking to respond to that offers him absolutely no benefit. She has made her rulings. Nothing is changing here. There is no topic of discussion even before the court presently that requires an argument. He is so beholden by his own selfish needs to argue and to manipulate that he's actively hurting his case in spite of those needs. He's like the monster eating his nose in spite of his face. He can't control his fragile little ego long enough to just fight the case on its merits. Instead, he spends his days just bickering and bullying with everybody else in the courtroom with no frame of reference for what he's doing or how successful he is in doing it.
What would you like to put on the record as it relates to the specific issue for which I was giving you the opportunity to be heard? Not anything else, not subject matter jurisdiction, not
Now you
whether
said
the
that.
state's doing
I didn't
other
even
things.
bring that
I'm
up, Your Honor.
only asking you to address the offer of proof.
No,
if
I
you
wanna-
have something, go ahead. Only as it relates to
I want to
that.
address your position because you said you're like the umpire, right?
Well, I'm not getting... Okay, go ahead, sir. I'm not sure why you need to respond to that.
Because it needs to be on the record. If you're the umpire, that means you're the referee.
That's what I'm doing here today, sir.
And when you're not reffing fair if the jury's not allowed to hear things that's important for them to know.
I respectfully disagree, sir. Again, just because you believe the law means you have a right to question all these witnesses about who the plaintiff is and about subject matter jurisdiction doesn't
I didn't
make
question
it
anybody
so.
about that.
What?
What?
Are you fucking kidding me? Dude. No.
You recall ever being told about the plaintiff in this matter? Do you know if there's even a plaintiff in this matter? Ever spoke with the plaintiff in this matter? You ever seen the plaintiff in this matter? Had any conversations or any interactions with the plaintiff? Ever had a phone conversation with the plaintiff? Ever been contacted by the plaintiff in any way? Are you even aware of a plaintiff in this matter? Ever been notified who the plaintiff is in this matter? If you yourself ever had any interaction with the plaintiff? Do you even know if there's a plaintiff in this matter?
Just trying to establish who the plaintiff is, Your Honor.
Have you at any time seen anywhere or read anywhere that there's a plaintiff in this matter? To the best of your recollection, do you recall being contacted by the plaintiff in this matter? Was the plaintiff's name on the subpoena? Are you aware that in any case brought into a courtroom there has to be a plaintiff? Are you aware of who the plaintiff is in this matter?
Objection, relevance.
Grounds.
Overruled, he may answer.
I believe that you would be, or excuse me, you're the defendant.
I would be the plaintiff?
Excuse me, at my mind. You're the defendant, I believe. The plaintiff would be.
If you know, do you know who the plaintiff is?
All those who were hurt under the title of the state of Wisconsin.
Have you ever seen the state of Wisconsin at any time? Is the state of Wisconsin an injured party in this matter? Do you see the state of Wisconsin plaintiff in court today? If you were to see the plaintiff state of Wisconsin, will you be able to identify him? The plaintiff is the state of Wisconsin. Do you see him present in the courtroom today? Can you identify the plaintiff state of Wisconsin? Have you ever had any interactions with this entity, state of Wisconsin? The defense would like to call the plaintiff state of Wisconsin to the stand.
Your Honor, I
Object.
As do I. And, putting that compilation together made me think, if you added up all of the useless questions that Darrell asked throughout the course of this trial, I think it would literally add up to days he wasted asking pointless, irrelevant, objection and sustainable questions to parties that had no information there otherwise. It's absolutely preposterous. I mean, listen to this claim he makes.
You believe the law means you have a right to question all these witnesses about who the plaintiff is and about subject matter jurisdiction.
I didn't question anybody about that.
Even if you were to give him the benefit of the doubt and assume that he was referring to not asking questions about subject matter jurisdiction, I could spend another few hours putting together a compilation where he asks people about that, because he does do that too. Ugh. Alright. Let's move on.
All right, thank you. The jury can come on out.
So we're not going to address this civil matter?
No.
shut it down.
I'm told to pay for something under a civil statute.
Mr. Brooks, I am not the custodian. Bring it up with the clerk of court.
How
I'm
can
not
I bring
addressing
it up
it.
with the clerk of court? How am I supposed to do that? So that makes me wonder if it's a
Mr.
civil
Brooks,
case.
the jury's coming out. I'm not going to
it's-
address your request
if
for
it's
open
civil-
records.
if it's
That's,
civil,
I'm not
then
the
it needs to
custodian
be
of the records,
who's
sir.
being sued. My Sesty Trust is being sued?
Oh my god, I could feel that sigh in my bones! If exhaustion were a sound, Judge Darrell's sigh would just be like its ultimate form. Like, give me a fucking break, guy. In what world can you fill out a few legal documents and get the government to basically pay off your murder charges and punitive damages? You're real. Like, there was a defense going into this. It would have 1,000% been rejected, no matter what the basis was. But it would have better than this. Like this? The pay off my victims with the hidden government funny money? It ain't it, bro.
Civil is a
Mr.
civil
Brooks, this
matter.
is an irrelevant matter that you're attempting to bring up in the presence
If it
of the
was-
jury. The
I
record
was
should
not. I was
reflect
trying
these
to bring it up
interruptions.
before the jury came out, Your Honor.
And I
know
told
that.
you I wasn't going to address it. Please.
Okay, so it's a civil matter. Who's being sued? My safety trust, because how can I be
Mr.
sued?
Brooks, you're talking about an irrelevant matter between you and the
It
clerk
wasn't,
of court.
it wasn't irrelevant
So-
when I got the paperwork from the clerk of courts. I was simply
Mr.
trying
Brooks,
to address it.
I'm not going to address it. The jury will
So I'm
disregard
being
these
sued.
irrelevant
This is a civil
comments.
matter. We haven't addressed subject
All right,
matter
thank you,
jurisdiction yet at all
everyone.
either.
Please be seated. The jury
So
will
we're not gonna
disregard the
address subject
statements
matter?
Mr. Brooks is making about subject matter jurisdiction. They are a misstatement of the law.
Yes. No,
All right,
they're not.
and
Just like this is a civil case.
Mr. Brooks, the jury's here. Please
Just like
show
this is a civil
respect
case.
and decorum.
According to this document, this is a
Mr.
civil
Brooks,
case,
please stop.
which means someone is being sued. Civil is a suit.
Mr. Brooks, you're talking about an irrelevant
I have
matter.
the
I'm
paperwork
starting
sent
the
by the
trial.
paper course right here that says it's a civil matter.
Mr. Brooks
So
has
what's
nothing
being
to
sued?
do with
My
this
safety
case.
trust is being sued.
I have no idea what you're talking about. So,
I got the paperwork right here.
all right, I'm
How
going
do
to
you not
excuse
know
the
what I'm
jury
talking
right
about?
now, given this disruption. All rise for the jury.
This should be properly addressed before the jury even comes out. That's why I tried to properly address it before we even went on the record.
Mr. Brooks, stop.
It's time to stop!
I'm not gonna. This is.
You are not
I was
being
given
respectful
this
to this
paperwork by you, Your
proceeding
Honor,
or to
with
this
all respect.
jury. No, it's
With all
not.
due
With all due
respect,
respect,
with all due
stating that
respect,
doesn't make it
I was given
respectful.
this
Thank you!
paperwork by you.
Mr.
from
Brooks,
Monica Paz.
stop talking
The
till the
clerk of
jury
court.
is out.
Okay,
Thank you.
So why couldn't we address this before they came out?
I'm
That
not
was the
going to
time-
address it,
That
bottom
was the
line.
time to address it, though.
You are so dumb. You are really dumb.
We're supposed to do all the addressings before the jury comes out, before we start the matter.
Please
I
be
was trying to
seated.
simply address paperwork that was given to me by you, Your Honor. That states that
Mr.
this-
Brooks,
it states that
you
this
have
is a
interrupted
civil
me
matter.
repeatedly. You are on the verge of being removed to that courtroom.
Get the fuck out!
I don't want to
On-
do
on
that.
what-
I want you to stay here.
on what
But
fact of the
you
law, Your
keep
Honor?
interrupting me and bringing up irrelevant matters. I told you yesterday, as a courtesy that was provided to you, so that you would frankly not complain that you didn't get it as quickly as possible. Okay.
See, that's the problem with these kinds of people. You give them an inch, and they not only demand a mile, they, like, come to expect it. You've now, like, set the precedent. You know, do you guys, like, know somebody like that? This is literally just, like, out to game on anything they can. Like, they'll be out there stealing shit they don't even need or lying about things for no reason. You know, like, they come over and you feed them. Like, I'm taking a nice little shower, some, you know, they pass out on a couch and you think, like, nah, what's the harm in them spending one night? And before you know it, you turn around and you and that motherfucker are roommates. Their name is, like, on the lease. They got keys made already. Like, you like turn around like, how did you get keys made? I've had this set the whole time. They're like down there chiseling a key out of stone, taking it to like a 3D printer. They're doing that thing with the notebook, you know, where you take the pencil and the graphite and you scratch out to the side of the key. Oh, getting the outline, and then that's it. It's a wrap. You know, like game over. This house is now ours. Fucking bless our mess. You gotta go get like one of those fucking bless our family shits from Home Goods, because you, sir, now have a wife. You guys know what I'm talking about? Those stupid little cutesy signs that say like, bless this mess, or like, family makes this house a home. Like, bro, you don't live here. It's Darrell. Oh, I could totally see him doing this, running up on somebody and just fucking digging in, making himself at home.
Okay, I am not the custodian of the records. If you have an issue with what was provided to you, how it was provided to you, then take it up with the clerk of court.
can't
But
charge
from
you.
now on, I am not going to be the messenger and give you documents that you request to the custodian of the records or from the custodian of the records. They will simply have to be delivered to you at the jail. But that is in response to your discussion or whatever we want to call it this morning. I'm not taking it up
It should.
All right? It is irrelevant.
It needed to be noted for the record.
It doesn't
Because
need
it
to be
was-
noted, sir.
You
All right,
gave
the
it to
jury's
me-
coming
you gave
back
it to
out,
me
and I'm
open
going
court.
to warn you, if you bring this up again, I will pause and I will remove you to the next courtroom for being disrespectful, for being interruptive, for being disruptive, and for bringing up irrelevant matters in front of this jury. You will forfeit your right to be present for the direct examination of this witness.
I object to that,
Did you
Your Honor.
hear what I said, sir?
No, I did not. I object to that, Your Honor.
Well, you can
And-
object, and your objection is noted. But if you
For the
interrupt
record-
when this jury
for
comes
the
out,
record-
they will go. I will have them taken out again, and you will be removed to the next courtroom.
You can't. What is the legal basis for that ruling, Your Honor?
Illinois versus Allen, sir, and all of the
And-
other cases that
and it
I've
doesn't
cited
say
previously.
anything
I'll
that-
make the appropriate record. Stop interrupting me. The jury's coming out. We're continuing with this trial despite your repeated efforts to disrupt.
That's a
Yesterday,
mischaracterization
sit
of the
down.
record.
Yesterday alone, sir, 17 interruptions, not including the opportunity that I gave you where you spent 15 minutes, okay, discussing what were primarily either irrelevant or baseless accusations and requests not based in law or fact. I was abundantly patient with you yesterday.
And you still haven't
And-
verified by proof any of what I
And
said.
none of
Your
that
Honor.
is required, sir.
Because it
And
is. You can't verify.
your
any proof.
belief
Where's
that
the
that's the
subject matter-
law
where's the subject matter
doesn't make it
jurisdiction?
so, Mr. Brooks. Your belief that these are legitimate legal positions
They are.
doesn't change the law and doesn't make it so.
Out of curiosity, how did you come to the knowledge of that name?
It was on the subpoena I received last week.
You just stated a little bit earlier in testimony that you received your subpoena in July. Now you said last week.
Those are both correct.
So you received two separate subpoenas?
Yes, you fucking idiot. This is your witness. The state is doing their job correctly, so of course they subpoenaed basically everybody from the parade months in advance to make sure everyone was given ample notice. I know in your fucked up little narcissistic head it makes sense to like slap people you are anticipating to extract meaningful testimony from, more or less, with a subpoena the night before, and then just expect them to calmly sit there in the courtroom for the entire trial, basically, to just be at your beck and call. The problem with that is, a lot of people are just going to say, go fuck yourself, I have a family and a job that I need to attend to. I'm not spending my next couple of weeks sitting through this pathetic excuse of a trial. The state, however, has a team of seasoned attorneys that are surgical in the execution of their subpoenas, and probably even meet with them beforehand to get an idea of what testimony will look like before it's presented to the court. It's called preparation. And preparation prevents things like arguing with your own witnesses, or inadvertently opening doors to subjective testimony. Say, a music video, a horrific music video that makes you look pathetic, or your sex offender status, for example.
Correct.
What was the difference between the two?
One was from the district attorney's office and one was from you.
So the one that you received from the district attorney's office in July didn't have a case caption on it?
Okay, what's a case caption?
Just 1 second. 1 second, Your Honor, if I
Your Honor,
may
I'm just
have
going to
just
object to
1
this
second.
line of questioning. I really don't know what the relevance is for the purposes of this trial.
There was no objection at first.
But there is now.
I'm going to sustain the objection under 906-11, because I don't believe it advances.
I think
trial.
I think you know where I was getting at with the question.
Then you need to ask your question directly, sir. Go ahead, but I'm sustaining it as to the form of a question.
When you were subpoenaed in July by the district attorney's office, the subpoena didn't contain information to the case you were being subpoenaed for?
Objection to relevance.
Grounds?
Sustained, you don't have to answer that. I sustained the objection on those grounds. Ask the question I believe that you're trying to ask, not that one.
Was the name that you mentioned, Mr. Brooks, anywhere on the subpoena that you received from the district attorney's office in July?
Objection. Relevance.
Grounds?
Sustained,
Grounds for the sustained. That
not
was
relevant.
What? Mind-boggling.
This has been another iconic Darrell Brooks moment. This iconic Darrell Brooks moment is brought to you by Tapper's Pens. When you really want to get your point across, choose Tapper's Pens. We don't sell you the whole pen though. It's just like the small insert inside a normal pen thing that like has the ink, like the housing part that could possibly be used to like stab someone in the neck. Yeah, we don't give you that part. They're like little flimsy half pens for little flimsy half pen bitches to tap. Tapper's Pens. We're the tappiest.
Sir, in July when you received your subpoena from the district attorney's office, were you even aware what you were being subpoenaed for?
Objection. Relevance.
Grounds?
Sustained, not relevant.
She's testifying in the trial and it's not relevant that she got subpoenaed?
Mr. Brooks, she's here under your subpoena.
What?
You called her as a witness. It's
The
your
subpoena this is relevant because she
Mr.
was
Brooks,
already
under
subpoenaed.
90611, please ask the witness
This
a
is
relevant and
mind-boggling.
probative question.
This is mind-boggling. Mind-boggling.
Remind the jury that the statements of the parties or the attorneys are not evidence.
Stop muttering under your breath, you little broke back bitch. Say it to her face. If you're gonna sit up there and kee and hee all to yourself like a spoiled rotten little brat, have the stones to say it to her face. Oh, you little worm! You pathetic little worm!
So were you aware that it was a chance you would be possibly testifying in this trial?
Yes.
And did you know who the trial was for?
Objection.
Grounds.
Sustained.
Grounds for the
relevant.
sustained.
It's not relevant.
I've never heard of nobody testifying in a trial that they didn't know who the trial was for.
Mr.
think
Brooks,
I think
I'm
that's very
sustaining the
relevant.
objection under 90611, and I'm asking you to move on.
Y'all is ridiculous, man. Seems to me like a lot of your answers are coached. Is that fair to say?
No.
So the subpoena that you got last week, is that how you learned the name that you used?
Objection.
Grounds.
Relevance for the same reason I argued before.
Grounds.
Asked and answered. She's indicated the answer already. 90611, sir. Next question.
The question
Different
was,
topic.
is that the first time that she saw the name?
It's not relevant.
That
Next
was not
question.
asked and answered. That was not asked nor answered.
Under 90611, please ask a question, sir.
Man, what is y'all people trying to pull up, man? This is ridiculous.
Mr. Brooks, if you don't ask another question that's relevant and probative under 90611, then I will turn the witness over to the state for their cross-examination.
And then I should be able to get redirect, right? Your Honor?
Ask a question, or I will declare the examination
Shut it down!
by you to be ended.
It's not an examination, it's direct.
It's a direct examination. Sir, under 90611, you are directed to ask a question, or I will ask the state if they have any questions.
I heard you.
Thank you. Next question, please.
Know who the plaintiff is in this matter?
Oh, shit. Here we go again.
Yes,
Who's the plaintiff?
the state of Wisconsin.
Is that an entity or a living human being?
Objection.
Grounds.
Relevance.
Not relevant, sustained. Next question.
Have you ever had any interaction with the plaintiff?
Objection. Vague.
Sustained.
Vague.
As to the form of the
Have
question,
you ever had any interaction with the state of Wisconsin?
do not answer that question. Next question, sir. Under 90611.
Was there an objection or was that just a ruling? I'm not sure. You both was talking at the same time.
Under 90611, I directed the witness not to answer that irrelevant question. Ask your next question, sir. Mr. Brooks, ask your next question.
I'm gonna get to it.
Thank you.
So when did you first report your alleged injury?
You do not have to answer that question. Next question, sir.
Grounds for
90611, sub 1, sub A, sub B, and sub C.
is that lawful law?
All right, you may sit down. Does the state have any questions for this witness?
Shut it down!
Ma'am, that day on November 21st of last year, you were there with two kids?
I was, yes.
What were their ages on that date?
Objection.
3
relevancy.
and
Overrule, the witness may answer.
Of course it's gonna be overruled.
3 and 6.
And I don't know, Mr. Brooks can sit down. I'm kind of asking the questions right now.
Mr. Brooks, please sit down. Mr. Brooks, you're not asking the questions.
I'm not saying
I would
anything.
ask you to sit down, please. It is disrespectful to this witness and to the state and to the court.
No, it's not. Not doing anything wrong. I'm merely standing here.
I never sit in no chair, essay. You never ever gonna catch me sitting in no chair.
Yeah, when you were at the parade On November 21st of last year, approximately where were you watching the parade from?
Asked and answered objection.
Mr. Brooks, it's cross-examination. Just because you asked the question initially and she answered it does not mean the state doesn't get to follow up on it.
So the state can ask the same question I asked.
The state can ask their question.
So how
Go
come when
ahead.
I did that, it
Overruled.
was
The witness may
it was
answer.
sustained?
Because that was direct. And this is cross. They can do that. Had you taken the time to learn the rules of procedure, or even, courtroom etiquette at its basics, you'd know this. But no. By all means, keep on keeping on with this, floundering technique you have with blinders on. Really, it's it's been truly effective for you thus far. I mean, half of your questions and nearly all of your objections are just rejected immediately, and you're making arguments that aren't even grounded in reality, let alone law. Yeah, good luck with that. Ugh, he's fucking irritating the shit out of me. Let's move on.
That'd be fair to say.
Objection, count home question.
Sustained as to the form of the question. Please rephrase.
Just from strictly looking at this picture, you can't positively say what the item is.
Objection, that's a mischaracterization of his testimony.
Sustained. Please rephrase.
Clear the photo.
You're asking Madam Clerk to please
Clear the
clear it?
photo.
Mr. Brooks, I'd ask that you show some deference to my clerk and not bark orders at her and use simple courtesy. Thank you. And thank you, Madam Clerk.
Will I be awarded the same, Your Honor?
Bro, what is he even on about here? It's like that spoiled kid at the birthday party that gets jealous he's not the center of attention. And she's, said, show my clerk some respect. He's like, well, what about me? It's like Cartman when every time Kyle opens a present at the birthday party, Cartman has to open one too, or else he'll throw a tantrum. I mean, he has been treated with the utmost amount of deference and caution. More so than probably any other litigant in the history of courtrooms. I genuinely cannot think of how they could be any more courteous to this guy. Like, if he was asked to provide even one example of somebody being disrespectful to him, the closest thing he could point to would be, somebody laughing at him. Which is probably involuntary because he's just so fucking stupid, it's amusing sometimes.
Please ask your next question, sir.
Will I be awarded the same, Your Honor?
Please ask your next question.
I will. I just want to know if I'll be awarded the same.
Thank you. Please continue.
I don't recall.
Did you ever make any statements to law enforcement after the incident at any time?
My wife and I both shared information on behalf of the crash report and our findings, or our initial statement.
You recall if that was the same night of the incident or in the following days after?
That was the following days.
Do you recall if it was a few days after or maybe a week or two?
I don't recall specifically. I believe probably within a week or so.
Any idea why it took so long for you to give a report? You and your wife, rather, to give a report?
Yeah, just dealing with my daughter and getting her situated and just the magnitude of the incident. I think it took them a little bit longer. I think we were in contact pretty quickly, but it just took a while for them to get the resources back to us to collect everything.
Did you initially initiate the contact which attempting to file a report?
I can't recall specifically. It's been close to a year, but I believe we did reach out to the DA's office at some point in the following days.
Did you do any follow-up after that initial contact? to see if maybe your report had been filed or anything like that?
At that point, the DA's office stayed in contact with us to let us know that everything they needed had been captured.
Do you recall who you talked to from the DA's office?
I don't recall.
Do you recall do you recall being told that you may be called to testify in this matter?
I do.
Were you seeking to testify in this matter?
I know I was subpoenaed directly from the state, the DA's office.
So you didn't have any intention to testify in this matter before being subpoenaed?
I knew it was a possibility. I never reached out to request to testify. I let them do their job, and they reached out to me to let me know that I would get subpoenaed.
Have you read or seen any complaint in this matter?
Objection day.
Grounds?
Sustained.
Have you or your wife filed any claims in this matter?
Which claim? Define claims.
Referring to being an injured party or anything of that nature?
We submitted a claim with the DA's office, I believe, for potential medical reimbursement.
So that would be in regards to the medical bills?
For my daughter, correct.
So would it be fair to say that you have a financial interest in this matter?
Okay. That's just fucked up. Yeah, bro. He's faking the injury of his fucking grammar school daughter for insurance payouts. Jesus Christ. His financial interests are probably attempts to, like, recapture a percentage of his losses at this point. I can all but guarantee it. Throughout the rest of this entire family's life, they will probably need both medical and mental health services, and will probably still never fully recover from the shit that you put them through. Fucking douchey Darrell. Oh God, and you trying to spin a narrative around that is like, it's so fucking gross. Especially knowing you then go on to morally grandstand on everybody else for crafting narratives about you. God, like, it would be ironic if it wasn't so tragic. Fucking monster.
Objection.
Grounds?
Relevance.
Grounds?
Sustained.
Would you consider yourself to be an injured party in this matter?
Me personally, no. Not physically.
So you weren't injured in any way in this?
Not physically injured, no.
Are you aware of the plaintiff in this matter?
Objection. Relevance.
Grounds?
Sustained.
Ever had any contact with the plaintiff in this matter?
Objection.
Grounds?
Vague. Sustained.
Ever had any phone conversations or personal interactions with the plaintiff in this matter?
Objection.
Grounds?
Again, with regard to the nature of the question, it's vague.
Sustained.
I don't believe that's vague, Your Honor. I asked specifically if there were any phone conversations or personal interactions. I don't think that's vague. I think that's pretty clear.
Sustained.
And I also believe the jury deserves to know if there is a plaintiff in this matter.
Your objection's noted. It's to that particular statement. Your statement is noted. To the objection from the state, it is sustained. Next question, please.
Are you aware if there even is a plaintiff in this matter?
Objection.
Grounds?
Sustained.
May I have the grounds for the sustain, Your Honor?
Relevance.
I would object and say that it's very relevant. Again, citing
Your
that.
objection is noted. Next question, please.
The suspense is terrible. He's gonna go this time. I hope it'll last.
Were you ever contacted by anyone who identified as the plaintiff in this matter?
Objection.
Grounds.
Sustained. It's still vague.
That's pretty clear, Your Honor. The jury deserves to know this information.
Mr. Brooks, the objection has been sustained. Next question, please.
No further questions.
Thank you. Any redirect?
Briefly. Sir, at cross-examination, you had testified that you did not see any brake lights. Is that correct?
That's correct.
Objection.
Ground.
Relevancy.
Overruled.
Alright guys, well, I will pretty much do it for this one. Really hope you guys liked it. Man, I worked really hard on this video. It took forever. I mean, even just writing that rap song in the beginning and then editing it all together and the animate. I'm not going to get into it, but gosh darn did it take me. This video I worked really hard on it, so I really hope you guys liked it. Guys kept saying you wanted more of these long-form commentary videos on Brooks, so here I am, doing my best to give you guys what you want. Ask and you shall receive. Before we go, I don't know if you know him, but you've probably seen his videos, if you're watching mine, because he makes a lot of Darrell Brooks content, and the algorithm has probably been throwing his videos in your face like they do mine. But I was recently on Pack Nation with Alistair. Him and I did his live stream. It was tons of fun. We just kind of shot the shit for a couple hours. We got into my backstory a little bit. Talked about his obviously as well. So if any of you are curious about, how I got started on YouTube or what my personal life looks like beyond making these dank Darrell Brooks meme garbage compilations, then you can check that out. I'll, do the usual link to the video in the description. Beyond that, do all the typical YouTube-y stuff, like subscribe, leave me a comment. That really helps. If videos get engagement, YouTube's more likely to, push it out there. Even if it's just something, like a one key, just like toss a monkey emoji down there or something. I love those monkeys. I use them. You know what? Let's do this. If you like this video and you're hearing this, so that would mean you watched it the entire way through, do me a favor and drop me your favorite emoji in the comments. It'll take 2 seconds, and it really helps the channel and will push this video so other people might see it and like it too, and it'll really help me out. And I would really appreciate it. I'll even send one back to you. We can turn it into a fun little emoji back and forth. Okay? Alright, well, anyways, like, subscribe, join the Patreon. It's only $1. Buy the Judge Dorow t-shirt. The Judge Dorow t-shirt. Come on, come and join the Discord if you want to do the Case Watch series with me. We're recording tomorrow again. Today's Saturday. We're going to start day 3. And then the week after that, Alistair from Pack Nation's going to come on. I think we're going to do the other half of sentencing, but that will be a lot of fun. So we got a lot of fun things lined up. Keep your eyes peeled. We're going to be talking about even doing possibly like a charity live stream. Jennifer Darrow's got a new case that's starting on the 25th. That's going to be live streamed, and we were thinking of maybe doing a charity live stream where all the proceeds would go to one of the victims' charities. So that could be fun. If you're out there and you make content or even art or something, music, hit either me or Alistair from Pack Nation up. We're talking about maybe doing that. It's still very much in the works, but we'd love to have as much participation as we can. I'm sure those charity foundations, if and when they agree to participate, would as well. So okay then, all the YouTube-y stuff is done. Have a happy Easter if you celebrate that. And I'll see you in the next video. Okay? Alright, guys. Bye now.